Joining me now is a very good friend of our show, the esteemed Judge Michael Luttig. For roughly 15 years, he served as a federal judge on the U.S. Court of Appeals for the Fourth Circuit. Judge Luttig, good morning to you. Thank you for being with us.
Good morning, Ali. Thank you for having me with you.
Prior to this week, Judge, a lot of legal experts and court watchers expected the Supreme Court to uphold the ruling from the Court of Appeals, which you've called masterful. And I want to just read one part from that ruling. Quote, "We cannot accept former President Trump's claim that a president has unbounded authority to commit crimes that would neutralize the most fundamental check on executive power, the recognition and implementation of election results. Nor can we sanction his apparent contention that the executive has carte blanche to violate the rights of individual citizens to vote and to have their votes count. At bottom, former President Trump's stance would collapse our system of separated powers by placing the president beyond the reach of all three branches. Presidential immunity against federal indictment would mean that as to the president, the Congress could not legislate, the executive could not prosecute, and the judiciary could not review. We cannot accept that the office of the presidency places the former occupants above the law for all time thereafter," end quote. And Judge, as you've pointed out, by deciding to take this case, it means that at least 4 of the justices agreed that it's worth listening and determining whether the lower court erred in its judgment.
That's correct, Ali. It is of enormous constitutional and political consequence that the court decided to take this case, to take it when it did, to set argument when it did, and decide it when it is likely to be decided. As you noted, the court has set argument for April 22nd. That's quite a bit of time from today. And more importantly, that's only about 2 months before the end of the court's term, roughly around July 1st. It is possible for the court to move swiftly and decide this case before the end of the term. I think that that's highly unlikely. I think it's far more likely that the court will issue this opinion the last week of term. This case is of surpassing constitutional importance. It will be a landmark case. There's no equivalency between this case and the Nixon case that you referenced in your setup. This case is far, far more important for the country and for the Constitution than the Nixon case. We don't know from the mere grant of a review in this case what any of the justices might be thinking. As you said, it took 4 votes to grant the case, but that doesn't mean that any of those 4 justices have any intention of reversing the Court of Appeals for the District of Columbia judgment. We just don't know. At most, we can infer that at least 4 justices believe that it was important that the Supreme Court of the United States decide this case.
Judge Luttig, let's go back to the math for a second. 51 days before they hear it, then, as you said, possibly the end of June. Let's call it July 1st, just for argument's sake. Then, if Judge Chutkan is permitted to move on with this case, there are 88 days that the defense has before this can go to trial, which basically takes us to the end of September, beginning of October. Tell me how that math works out. In other words, it's possible that this trial, if it happens, could be delayed that late. Is it practical for this trial to begin at the end of September, beginning of October?
That's exactly the question, Ali. On that timetable, the earliest that the trial could begin would be the first week in October, essentially 1 month before the 2024 presidential election. It would be a very, very difficult decision for Jack Smith to begin the trial 1 month before the election, knowing that the trial itself would span through the election and perhaps almost to inauguration. if the trial were to last 3 months. That is a tactical decision that Jack Smith would have to make if the timetable worked out as we've just sketched it out.
Judge, in its order announcing that it would take up Donald Trump's appeal, the court wrote, quote, "The petition is granted limited to the following question: whether and if so, to what extent does a former president enjoy presidential immunity from criminal prosecution for conduct alleged to involve official acts during his tenure in office," end quote. Some analysts have expressed concerns about the framing of the question. Does any of that give you pause?
No, it does not, Ali. First off, your viewers should understand that the court always frames the question presented, the question that it's going to decide. And that's what it has done here, no more, no less than it does in every case. The parties proposed the question to be addressed by the court. And in this instance, both Jack Smith for the government and the former president framed the questions differently from each other. And it just so happens, though it's not unusual, that the Supreme Court framed the question differently than both of those two parties, so as to require briefing and decision on the question that the court itself wants to decide. Now, what is that question? There's been a lot of discussion as to the framing of the question. In my view, a lot of that is a tempest in a teapot. At the end of the day, the court has asked the parties to brief the question that's at issue in the prosecution of the former president, namely whether the former president violated the Constitution when he, acting in his official capacity as then President of the United States, sought to overturn the election in 2020 and obstructed the official proceeding of the joint session of Congress to count the electoral votes. The court, of course, can decide the question as narrowly or as broadly as it wishes, but this is a paradigm of a case where the court will almost certainly decide the case as narrowly as it possibly can. And if it were to do that, it would decide, in my view, whether a former president, can ever be immune for attempting to remain in power beyond his 4-year term, his constitutionally prescribed 4-year term, denying his successor the powers of the presidency, or attempting to deny his successor the powers of the presidency, in violation of what's called the executive vesting clause of the Constitution of the United States. That's the narrowest question, as I understand it, that the Supreme Court would decide and indeed must decide.
If it makes you feel any better, I have already put EVAC on alert. He's ready to go if it comes to that. General, I can assure you.
Hey, General, let me into the war room to see you, so I had to hack my way onto this frequency.
This better be critical, Wheelie.
So, come on, what is it now, please? Okay, couple of things. I wanted low on the double. I was thinking about taking a couple of months sick leave, maybe starting today. And, oh yeah, I intercepted a transmission from Megatron.
Then send it through.
Yes, sir, right away, sir. And so I was so damn weird going on the other stuff.
This is your last warning, insects. Relinquish what remains of the Allspark.
So who's the insect? You? What? Who's the insect?
Protect you. They will defeat it on our world, and we will defeat them here.
The Megatron.
This was just a diversion. Security, please bring him up. Rabbit, she's already inside. Deeds! Give me an update on that reserve. Boss readiness. What was his name? What was it?
Evac, sir.
Right, evac.
She's right in front.
We're facing a the sustained attack. They appear to be after the all-star character.
General.